Hi folks, my name is Sergey Lemberg. I run the consumer law firm of Lemberg & Associates. We have a website here, stopcollector.com, that has a lot of information about collection law and fair debt collection law and how to stop debt collectors from harassing you. Today I want to talk to you a little bit about third-party contact under the Fdcpa. What can debt collectors do? What can they not do? The first rule of thumb for you to remember about third-party contact: debt collectors may not contact third parties except to find out or to verify your location information. Now, that's a real important prohibition under the Fdcpa. It protects you from embarrassment, which comes when debt collectors contact third parties. The second thing you need to know is that once debt collectors have your information in their system, they know where you're located, they know your phone number, they can't contact third parties. Simple rule. Why is that? Well, gee whiz. There's nothing for them to verify. There's nothing for them to obtain. There's no reason for them to call. They already know where you are and how to find you. It's just that you're not returning their calls. That's not enough of a reason for them to contact third parties. The third thing you have to know is that in most states, spouses are not considered third parties. So when a debt collector calls your spouse and talks to them about your debt, for the most part, not everywhere, but for the most part, that wouldn't be illegal. However, children are third parties, parents are third parties, siblings are third parties. So remember, spouses are not, but children and siblings are. The fourth thing you need to know about third-party contact is that debt collectors sometimes call people's workplace, sometimes call the receptionist, leave messages about the debt, or talk to supervisors about the debt. Those are third parties. Your receptionist at work, your co-worker at work, your boss at work. Those are third parties. Contact with them is prohibited unless you consent to it or unless there is some other good valid reason for them to contact these third parties, such as to garnish your wages if they already have an order. The fifth thing you have to remember is it's a violation of the Fair Debt Collection Act for a debt collector to tell anything about the debt to the third party. That's right. They can't say so-and-so owes a debt. They can't say so-and-so owes the debt to Citibank. They can't say the name of their company unless they're specifically asked. It's very restrictive, and typically debt collectors will break this rule. They will reveal this information. So, these are the 5 things you need to know about third-party contact under the Fdcpa. If you have a question, problem, concern, if debt collector is contacting third parties to collect your debt, you may need legal representation. You may have a case against the debt collector for the harassment, embarrassment, and abuse you are sustaining. Give us a call, see if we can help.